So first we're going to talk about documentation and progressive discipline. And what I want to focus on for this portion of the presentation is smart performance management. I mean, with employees, obviously you get the good, you get the bad, and you get all kinds of everything in between. And our focus as managers and supervisors and business owners and HR professionals is, of course, to support the success of our people. And if we treat them well, they will treat us well. We want people to come to work every day and feel motivated and feel that they are invested in what they're doing. So how do we make sure that we are getting the best from our employees, making them feel positive about what they're doing, and at the same time protecting ourselves should there be problems, should there be a need for discipline, should there ultimately have to be a termination? Because I'm a lawyer, I'll tell you, a lot of times legal claims result from termination of employment, even from discipline and other adverse actions that you may take over the lifetime of an employment relationship. So smart performance management. Obviously, complete, accurate job descriptions, very important. Frequent open communication, very important. Communication, and what could be more simple, but it's actually very challenging because when those tough conversations arise, they're hard, and a lot of us want to avoid them. We're conflict averse. We want to just, put our head in the sand and hope it gets better. But if people don't know that there's a problem or don't know what your expectations are, how can we expect them to meet those expectations and to improve? Regular written performance appraisals are very important. I encourage you all to at least do them annually, and then in addition when there are specific problems. And of course, documentation is absolutely key. Now, why is documentation essential? Number one, it supports what I was just talking about in that it is the foundation for communication, good relationships, mutual discussion of expectations, how to improve, how to invest in the success of the employment relationship. But it's also the documentation that is going to be the foundation of a good defense should there be a legal claim. Many times I get calls from my clients who are employers, and they say, this person is horrendous. They're never on time. They're rude to our clients. We got to get rid of them. We have to terminate them today, if not sooner. And I say, okay, let's slow down a little bit. Can you send me their personnel records? And what do I get? Oftentimes I get a practically empty folder. Right, guys? Right? Okay. Because although this is the most horrendous employee, we've never gone to the trouble of communicating with them and documenting that communication. Or we've communicated with them, but we've never gotten it into the record. And what do I want to see when you tell me this employee has serious problems, ongoing problems, incurable problems? I want to see documentation of this. Because
what's even worse, I would say, to getting a personnel record
that
has nothing in it, is getting a personnel record that includes reviews that are really very good. Because it's hard for people in a one-on-one. It's hard for many managers to sit across the table and criticize an employee. So we get the call, Tamsin gets the call, this person's terrible, we look at the file, oh, you got meets expectations or exceeds expectations, and
then you got a problem. Very good point, yeah. So we have positive performance information or we have no performance information. And then should there be a legal claim because the person feels that they've been treated unfairly, they've been discriminated against, harassed, or retaliated against, they feel that there's some kind of breach of contract when they're terminated, they come back to you, and we want to be able to show that you had a legitimate business-based reason to terminate this person. You want to have that track record. Many times, a syndrome that I see is, okay, we've either, as Gary said, positively reviewed this person and it was a mistake, or we've not put anything in the record and it was a mistake, and now we're ready to terminate them. And so you've heard this, let's create a paper trail. Okay, so at the very last minute, you give the person a performance improvement plan. And the performance improvement plan is a plan that would be impossible for them to meet within whatever the time period that's set. And you don't actually meet with them or support them or help them meet the goals of the performance improvement plan. It's all a big sham. And that's a big mistake too, because of course the documentation up to that time doesn't support it, and then your conduct in doing this performance improvement plan undermines any kind of argument that you might make that you were actually trying to constructively communicate, invest in success, support this person, help this person. So I am a big, big supporter of documentation, communication. It will help you should there be a legal problem. It will show that the decisions are not arbitrary, that these things have occurred over time and that you've invested and worked with this person. Obviously, it's important that they're accurate. As Gary said, make sure what's in the file is accurate. And of course, it preserves history because memories fade. Before we get to progressive discipline, I just want to remind you that should there be a successful claim for discrimination, harassment, or retaliation under the Fair Employment Practices Act in Massachusetts, under the Americans with Disabilities Act, under any of those acts, actually, what's going to happen is there's going to be a suit in the MCAD, a claim in the MCAD, the Mass Commission Against Discrimination, and or the Equal Employment Opportunity Commission, which is a federal agency, and then that can proceed to court. The plaintiff's lawyer, the lawyer for that employee, is going to be looking for this documentation. They're also going to be looking for depositions, meaning that you will have to, as a decision maker, an HR professional, or a supervisor, give your testimony under oath during the process of litigation. And so things can get very difficult. And the easier you make your job and our jobs to defend the case in advance by working with somebody and communicating and documenting it, the easier your life will be and the faster you'll be able to dispatch with that potential big problem and nip it in the bud. Hopefully you can avoid it happening, the legal claim happening again, at all. Now, in Massachusetts, we do have individual liability under our Fair Employment Practices Act. So it's very important that you and your supervisors and managers and HR people understand that not only is the company potentially liable, but also you as an individual, if you are the supervisor, manager, if you've been accused of somehow being involved, aiding and abetting the discrimination or harassment, or being responsible for retaliation, or in any way interfering with the person's opportunity to pursue their rights under the law, that you personally can be liable. So that means you or your manager's personal houses, cars, kids' college education. So this is serious stuff, and it's not just the company that could potentially be on the hook. So why progressive discipline? Progressive discipline is fair. It gives people an opportunity to improve. It gives you an opportunity and sort of a framework for communication. We start with a more mild form of discipline, a conversation, a counseling, maybe an oral warning, then a written warning, then a final warning. I do not advise that you have a set in stone progressive discipline policy in your handbook. I think that's a mistake because in many situations, depending on the circumstances, depending on the personalities involved, you may not be in a position to go through each and every one of those steps, and you don't want to promise your employees that you will. Progressive discipline is good because it demonstrates flexibility, good communication, support of the employee, a true commitment to improvement, to solving problems. But if you have a policy that's rigid, then you can't be flexible, you can't make decisions based on the individual circumstances. Fairness, consistency, use that policy, use progressive discipline, and it's a motivational tool, obviously. It's an opportunity to tell people, here are our expectations, and if this doesn't improve, unfortunately it could get worse. So let's work together and make sure it improves and we solve this problem now. So elements of effective progressive discipline. Again, you want to articulate the expectations of the job, the expectations for performance. Centralization. You do this through HR, you do this through whomever holds your personnel records and is responsible for personnel policies and practices so that there's consistency, there's communication, and it's coming through a centralized person so that you don't have different managers and different supervisors doing things in completely different ways without any guidance or communication within your organization. Progressive, again, it starts with a more mild form of discipline and progresses to a more serious form of discipline. Now, I'm talking to you and using the term discipline. I think it's important in the early stages when you're talking to your employees to be as open and forthcoming and positive and supportive and constructive as you can. But behind the scenes in our centralized personnel office, HR office, this is actually the beginning of building a record should we need it. Commitment to improvement. So many times I don't see this. We need a genuine commitment to improving this employee's performance, to working with them to make sure that, again, they're a happy, productive worker and they're meeting the needs of our business. Acknowledgement. What I mean by acknowledgement is that we want to make sure that there's a dialogue, that there is communication, and that it's documented in the file that the employee has received this information. Do they have to agree with the information? Do they have to agree with your assessment? Not necessarily. They always have a right, and we'll go over this later, to contest what you're saying and to put in the record what their point of view is. But we want to have acknowledgement that they have received this information. And we're going to talk about personnel records a little bit later and logistically exactly how you go about doing that. Okay, progressive discipline steps. Counseling, talking, verbal warning, having a conversation saying, if this situation doesn't improve, we're going to have to go to some kind of a write-up. And then it's an opportunity to have a conversation and talk about how we can all do better and how you can support this employee's improvement. A written warning potentially, a performance improvement plan, or what's called a corrective action plan sometimes. These are the goals that you need to meet within this time period. We will meet weekly to review your progress and try to be always in these issues in discipline and documentation as objective as you can, and focus on the job necessities, the job functions, the job responsibilities, not on personal issues. Keep it away from the personal and always refocus on the job description, the requirements of the job. This is all about getting the job done. And then, of course, ultimately discharge. Now, is this like a lockstep process where you have to do each of these steps? No. But these are the various pieces that you can use.
And I just want to share, Tams and I are in agreement that if you going back to that last slide, those are not lockstep provisions that you should put, that we would recommend you put in a handbook or an employee manual.
Definitely not.
You can get a lot of employee manuals out there on the internet. Sort of the canned versions will have that. We don't recommend it because you set some rules like that, and you can put all the contractual disclaimers you want in your handbook, but it'll create a set of expectations, and it could come back to bite you at the end, because sure enough, there'll be some step that you want to avoid. Now, some clients, we have some larger employers like the idea of a lockstep for purposes that the people heading HR want to know that their line managers are going to follow these steps. But for the most part, we don't recommend it. And if you have a handbook that could be read to have a lockstep progressive discipline, we would recommend you take a look at that and talk to us about that.
Totally agreed. And oftentimes when I work with my clients on their employee handbooks, my clients suggest or request that we put in what I consider to be sort of backroom information. I call it a procedures manual that's separate from what may be in your handbook. So as Gary just said, for example, you may not want to put, and we don't recommend that you put, an inflexible specific progressive discipline plan in your handbook, but it may be that for HR procedures, policies and procedures sort of behind the scenes, that these are our expectations and this is what we want our managers to do so that everything is consistent. Yes?
Are the first two steps documented in some way?
I'm glad you asked that, and we'll talk about this more. When we talk about personnel records, we'll talk about this more, but I'm glad you asked that question. Yes, that was an oversight. I didn't mention that. Even when it's a conversation What I always recommend is that you send just a follow-up email afterward confirming that we had this conversation and that a copy of this email is going into your personnel records. That's a very important piece. So even if it's oral, even if it's informal, I always recommend that you follow up with something that's documented. And it can be, very light touch, just an email confirming that we had this conversation, and always put on the bottom, this will be placed in your personnel records, because there are requirements under state law that people see anything that may negatively impact them.
I just had kind of a very broad question. I mean, my understanding is that employment in the state is at will. So do you have any statistical information given X number of terminations in the state, how many actually result in litigation that actually can be pursued? I mean,
I would doubt if that particular statistic exists. But if you go to the website of the Massachusetts Commission Against Discrimination, they have annual reports that always track how many claims there are in each various area, like age discrimination, sex discrimination, race discrimination, et cetera. So that might be interesting information for you to see. I don't think anybody's tracking how many people are terminated every day or every week.
Keep in mind that what the MCAD tracks or provides in their annual report is statistically derived from complaints filed at the MCAD. There's any number of, take that as a multiplier of claims that are asserted informally by demand letters. A terminated employee hires a lawyer, a demand letter gets presented to the employer, there's a back and forth and a resolution of that, and never gets to the MCAD.
Good point. So there are a lot more claims than you're going to see recorded anywhere because they are informally resolved. I'd like to share with you a case that I often talk about, which is the Ferguson case, Ferguson versus Host International. And this was a number of years ago, but it goes exactly to this issue of not putting in your handbook a promise that everybody is entitled to certain progressive discipline steps. And in that case, this guy worked at a Dunkin' Donuts in the airport. And Dunkin' Donuts is really fast, and in the airport especially. And they had a special. It was like 2 donuts and a coffee for $1.99 in those days. Maybe it's like $4.99 now, I don't know. And someone said, "What's so special about your special?" And he said, "Nothing." And he got fired. Now, there were other reasons why this guy got fired. Obviously, there was something brewing. There were issues with his employment. But they had made the mistake of having in their employee handbook a progressive discipline policy. And even though, as Gary mentioned, there were disclaimers all over this handbook saying, depending on individual circumstances, we may or may not enforce this progressive discipline policy. This handbook is not a contract, nor is it a promise that the employer will take any of the steps. The employer reserves the right to act in its own discretion, et cetera, et cetera. It doesn't matter. The Supreme Judicial Court decided this guy had a legitimate case, and they found in his favor that he was deprived of a contractual right to have those steps of the progressive discipline policy enforced in his situation.
So just to follow up too on that employment at will, some of you may be sitting there saying, wait, it's employment at will, why do we need to do all this? Well, the reason you're doing this and setting it up and documenting it is so that you're trying to eliminate the possibility that the employee is going to come back and say, oh, you did it for other reasons which are unlawful. I'm in a protected category, you did it because of my race, my age. If you go through these steps and you document, then you have a case in which you can say, no, here's the basis why we did. So the employee's coming in making an allegation, but there's no substance to it. So that's really, you're looking to try to avoid that and cut that off at the knees, essentially is what you're trying to do.
Right, to support the fact that this was a legitimate business decision. But also, I like to stress to have a good relationship with your employee and to make it a better place to work. Okay, do the right thing, be fair, be consistent. Consistency is so important that people in the same circumstances are treated the same way. We call it similarly situated people. Treat similar situations similarly. And hence the photo, the picture there, be flexible depending on the circumstances. Don't lock yourself into any particular commitment to particular progressive discipline steps. Documentation is essential, as we've just discussed, and here's what I have to say to you. Document, document, Document. Always document. And here's why. Should the employee be discharged? Should the employee be subjected to an adverse action and go to a lawyer, a mean, evil lawyer? You know how they are. The lawyer's going to say, why did you terminate my client? We want that documentation of that fair process. Every chance was given to this employee to succeed. If progressive discipline policy is in place, has it been followed? What do the documents show? Is this consistent with your past practices, the way you've treated other employees under the same circumstances? Are there any employment agreements? And if so, have you acted in accordance with those agreements? These are the questions that we'll be faced with should there be any potential legal action.